Hello, this is Jimmy Lee with Kukui coming to you today with Motor Age and with Daniela Lungu. So excited to have you here with us today as we talk about the basics of estate planning as well as the details of estate planning. So excited to lock arms with you. And as shop owners, we are coming together. We need to, you're not alone. And with Kukui, we want to bring you valuable information that helps you to progress and to succeed in your business. A lot of times you have questions about different areas of your business. You don't know where to go to get the information. We'd love to hear from you on those questions, on those areas of your business that you need an extra, just a little bit of help in pointing you in the right direction. You don't have to do it alone. Here at Kukui, we lock arms with you. You become part of the family. And we're so excited today to have on with us Daniela Lungu, as she is explaining the basics and the details of estate planning and what you can do to help prepare yourself for the future. And with that, Daniela, I turn it over to you. The floor is yours. Very excited to have you here today.
Thank you guys so very, very much. Welcome, everybody. I'm going to spend the next hour or so wowing you with everything that I know about how to die properly so that your family doesn't want to kill you later. And we're going to specifically talk about this topic, which is called estate planning. Really fun things that I'm really super excited about. And let me see if my presentation works. Perfect. So really quickly before we begin, this is my legal disclaimer because after all, I am a licensed attorney. I am not your lawyer. I'm not providing you legal advice. The purpose of this is really to give you some really pertinent information so that you can be educated on the entire process and how it may or may not impact your life or your business. So if you need to, please hire your own lawyer for your needs. Really quickly, this talk is generally geared towards California-based clients. I am licensed in California, although a lot of the law pertains to a number of different jurisdictions within the United States. It's specifically geared towards California clients. So if you happen to be out of state, there is some general information here that applies to you, but you do need to hire your own attorney to make sure that the specifics are what you need for your own planning. So goals for today. We're going to find out which documents are included when I talk about this whole concept called estate planning. What is an estate plan? How do all these documents work together, and why do we want them in a comprehensive plan? How we can use trust to avoid probate, which is a big one for most of my people. Learn how we can use trust to keep the court out of our family, right? We want to make sure that we have planning for ourselves and continuing for ourselves and not what anybody else wants us to do. So let's dive in. Estate planning, what exactly it is the planning process of determining what happens to your stuff after you pass away. So after you croak, what happens to all your things? It can also cover planning if you become incapacitated, think stroke, think accident, things like that, if you're incapable of handling your own finances or your own person. What estate planning does is a number of different beautiful things. One, it maintains control over your person and affairs. So during your life, you get to manage everything you have. And then sometimes after death, post-death planning, you can manage your assets and people, that kind of thing. It allows you to protect your kids, right? Think foster care. Think what happens if you become incapacitated or pass away while they're young. It protects your assets from lawsuits, creditors, and divorces. That is, of your children's or your beneficiaries' lawsuits, creditors, and divorces, not yours. There are these specific asset protection trusts, which I will not discuss at all in today's class, that talk about taking your assets and putting them into a foreign jurisdiction such as Grenada so that you can protect those assets from lawsuits that you have here in the United States. That is not what we're talking about today, and that's not what that bubble means. It provides for incapacity planning. It avoids estate taxes, which is one of the components we're going to talk about a little bit later, protects against administrative expense and delay. And I think the huge one that probably applies to most of us on the call is it avoids probate. So general documents, if you go to an attorney that's licensed to do this kind of work, these are the basic documents that everybody should have in every one of their plans. And I'm just going to do a quick list, and then we're going to get into the detail of each one. So one is the pour over will. The second is the revocable or living trust. Revocable, or you probably think I'm saying it incorrectly, revocable, is actually just a term that means you can make as many changes as you want to until date of death. Your advanced health care directive, your durable power of attorney for property, and then in my plans, I do a separate guardianship document for minor kids, and we'll talk about why a little bit later in this chat. So let's dive into some definitions. So the first is the simple will or pour over will or any kind of will. Quite frankly, it doesn't matter if you find a will on Google and you know do a search to figure out how to do your own will. Any will that is going to be valid has certain components of it that is tied to the jurisdiction that you're in. So for example, California has a specific set of things that are included. So every single will, no matter what type they are, will have these components. The first is you have to state that you're over the age of 18, which is the age of legal capacity here in the United States. I'm sorry, in California, not in the United States. The second is it states your understanding of what you have and who you want to give it to. That just means beneficiaries. So for example, you have 6 children and you don't like any of them, and you write a will that says, you know what, I'm over the age of 18 and I give my entire estate to my dog Willie, then that will is probably going to be called into question because you don't mention the fact that you have these 6 children. What the court doesn't want you to do is to forget that you have kids, right? Because otherwise they can file a petition to block the distribution to that dog. The next is it names your beneficiaries and executor. The beneficiaries are who takes from your estate, and the executor is the person that manages the will process for you through the probate. The next one is it specifies gifts. So I like this one specifically, so please make a note. $5,000 to my favorite lawyer lady, Daniela, and her dog, because I need a lot of help with her. That'd be really fantastic. You can put that in the will as well. A pour-over will is a specific type of will, and it usually is created the day that we create the trust, and it names the trust specifically as a beneficiary, and I'll explain later why that's really important. So all of these wills, whether they're called simple or complex or holographic, which means written in your own hand, or any of the other types of wills that exist out there, for all of them, the general component is that they typically have to go to probate. There's only a couple of ways of avoiding probate court. So that is the actual will. The next document, the trust. It acts a little bit like a contract, even though it's not a contract. It's an agreement between you as the trustee and current beneficiary during your life, and then it's for the spouse for their life if you have one, and then for the benefit of the beneficiaries after both of you pass away. So what it does is it provides for distribution of what's called funded assets. Funding is a specific thing that has to be done after you create the trust, and that simply means transferring title from things that you own as an individual to you as the trustee of your trust. So if you have a trust that is the Smith Family Trust, you, Jim Smith, have to own assets as Jim Smith, comma, trustee of the Smith Family Trust dated December 1st, 2018. That is how that asset gets funded into that particular trust. That is a very, very important and crucial component to planning. The trust, if done properly, if funded properly, avoids probate court, which we're going to talk a little bit later about what that is and why you should hate it as much as I do. It can be used to avoid or minimize estate taxes, and we'll talk about estate taxes a little bit in this talk as well. The next document, the Advanced Healthcare Directive. This gives your agent, the person that you trust, the ability to make your healthcare decisions if you become incapacitated and cannot speak. So what this assumes is that you are permanently unconscious. In medical terms, it's actually called GORCed, believe it or not. And that just simply means that you are permanently unconscious, you're not going to get up. And there's really two different elections on the form. One is to prolong life, one is not to prolong life. And you give somebody the ability to make those decisions for you. You say to everybody that's going to be bedside, hey, look, this is what I want, and then somebody gets to sign the forms on your behalf. The Advanced Healthcare Directive agent is the only agent that outlives your death only long enough to put into place any of your burial or cremation desires. For example, in my plan, in my own particular plan, I already paid for my funeral and the keepsake urns, and I sent a letter of instructions to my friends and paid for the party and did all that thing. So my Advanced Healthcare agent can actually make sure that they reach out to the person that's the contract holder and then carry all that out for me. This also avoids, surprisingly enough, probate court. It's called conservatorship of the person. So that is also a probate court action, which is quite expensive. Next document, durable power of attorney for property. This gives your agent, the person that you trust, the ability to make sure to keep you financially solvent. So use your money, keep you financially current, financially solvent while you're incapacitated but still alive. So think stroke, think accident, think something like that where you can't handle your finances for a short bit. Typically, I offer what's called springing powers, which means they spring into effect when two physicians have determined that you are not capable of handling your own finances. I don't typically give immediate power to anybody because I find that most of my clients want to be in complete control until they can't. So this actually also expires automatically at death. The second thing on this particular topic is your spouse, your significant other, does not have automatic rights over you. So even though you're married, your spouse has what's called statutory priority to apply for conservatorship on your behalf, but they don't have any automatic rights, particularly with respect to separate property assets. You want to make sure that you have paper to handle all of these issues. This avoids conservatorship of the estate, which is also probate court, and it starts at about $10,000 a person. Some other planning documents that I include in my plan, I do a separate guardianship nomination only because you can't prospectively assign guardianship to somebody. You have to actually get guardianship. You have to apply for it when there's need. So if you pass away, you have minor children, you write a guardianship nomination which says, these are the order of the people that I want to take care of my children. Those people have to file a petition with a lawyer in probate court that they have to have a fairness hearing. They determine what's appropriate. If the kids are old enough, they ask the kids at that point for input. And so I typically don't bury this language in the actual will because they don't need to have the rest of it. They just need to do this one particular piece. The last one that I do in my plan, typically, affidavit of intent to return home. This really has to do with Medi-Cal. Most of the people in where I do planning don't really qualify for Medi-Cal. There's a lot of stringent requirements for that, but Medi-Cal has the right to reimburse from your estate if you don't plan on going home. So if you go to a nursing home that's paid for by Medi-Cal, what this form simply says is wait until I pass away to send a bill to my family. Okay, so let's dive into the meat of this stuff, this estate planning stuff. So your planning options, if you have a will or a trust or both, typically in my live seminars, I ask, by a show of hands, what does everybody think? And sometimes it's equally split. I need a will or I need a trust or both, or I get the answer of, if I have a trust, why do I need a will? So we're going to talk about that. The answer is both, actually. I want you to have both, and we're going to figure out exactly why. So let's dive into some definitions. A will. It is simply a set of instructions that takes effect only when you're dead. So you write the language in it now, you die 20 years from now, and then whatever you write, that's actually what takes effect. So you can see why it's really, really important to make sure that you stay on top of that. If things change, for example, you don't like your beneficiaries any longer, or they predecease you, or you don't have the same things, that you want to make sure that you keep that language fresh. So the law provides for amendability, meaning you can make as many changes to this document as many times as you want to until the date of death. The trust is a set of instructions that actually is living. It means it starts to take care of you the second you draft it, right? It takes care of you throughout your life. It provides for whatever happens throughout your lifetime. And then after you pass away, what's going to happen with the beneficiaries. It is also amendable. You can make as many changes to your trust as you need to throughout your life. So both, you'll see, provide for distributing property after you pass away, right? In the trust, you can also do lifetime giving if you'd like. Both have no adverse lifetime income tax consequences. And what that means is, let's say Patrick, my dear friend Patrick, who's on the call with us, decides that the estate that he has, that he got from his Aunt Mary of $20 million, right? He has inherited this nice chunk of money. That is going to be mine when he unexpectedly passes away and lands underneath my pool. So when that money transfers from his estate to me as his beneficiary, I don't have to pay income tax on that. However, if I take the $20 million and I buy 5 auto shops with it, and then those auto shops make money, then I have to actually pay income tax on that, because that becomes part of what the 1040 and the Schedule C is, if that makes sense to you guys. Okay. Some differences between the wills and the trusts. Again, wills are only effective at death, so you write everything that you need to know now. It goes into effect 20 years from now, even if it's not fresh. Trusts, on the other hand, are effective immediately. Wills, without exception, or with minimal exception, should I say, have to go through probate, which is typically an expensive or long process for heirs, as opposed to the trust, which avoids probate if drafted and funded properly. Probates are public. What that means is when somebody dies without a plan in place, or with the default California plan in place, which we'll talk about later. A public petition has to be filed. The petition says, this is the person that died. These are their beneficiaries, names, addresses, ages. This is all of the stuff that this person owned, the house and the address of the house, the bank account and the bank account number, the life insurance policy proceeds. It actually is a very, very public petition, which means anybody in the entire world that wants to run down to the courthouse and pull up all the probate petitions that have been filed can do so. And then usually within a week or so of death of a probate being filed, the beneficiaries tend to start getting all of those sales calls, realtors and appraisers and all the people that are in the business of death. You know, that's who those beneficiaries get calls from because of that public. Trust or private, on the other hand, we do a simple trust administration, and unless somebody files a lawsuit, then nobody needs to know what's in the trust itself. Wills are only good in the state of residence as opposed to trusts, which are portable like a suitcase. And what that means is if you die in California and you have a will, you do not have a trust. You have a will and you have property in California. But before your death, you actually move to Colorado, for example, and you buy a condo in Colorado, and then you move to New York and you have a condo in New York, and you have a will is only in California. Then we do what's called an ancillary probate. So we do a will probate in the state of residence, and then we do an ancillary probate everywhere else where you have property. In this case, because wills are not portable, then you have to do a probate based on California law, which is where you drafted that instrument, right? As opposed to Colorado or New York. And then it just becomes a big hassle for your family to figure out exactly what needs to go in place or not. Trusts, on the other hand, are portable. So same scenario, you have a home in California, you put into your trust by way of funding, right? That means changing the deed. You move to Colorado, you buy the condo, put the condo into the trust. You move again to New York, you take the condo there, you put it into the trust. And then when you die, you do a simple trust administration. It doesn't matter where you are because it's not necessarily state specific. It actually is personal to you. So that is a much, much streamlined way of being able to transfer your assets to who you intend. So if you see right here in this grid on the left, we have a will, you have property, then it goes to probate, and then it goes to the heirs. And you can see on the right that by not having that probate, it's a much more streamlined transfer of things from you to your kids or your pets or whatever. So why use both? I have so many clients that say, God, why do I need a will and a trust? I don't understand why I need both of them. And let me just give you this graphic, and it talks about funding of assets. I can't speak highly enough about the importance of funding everything that you have and making sure it touches the trust. So typically when you have a will and a trust, at death, you essentially have both estates. And let me show you why that is. Because in life, your goal is to fund. That means transfer everything you own to your trust. So let's say we do an assignment of personal property to take all the contents of your home and your shoes and jewelry and bikes and collections and, inexpensive cars, that kind of thing, and you put them into your trust. You take that transfer deed, you want to make sure that every piece of real property you own, including those not necessarily in California, but I can actually fund real property everywhere else in the United States, into the trust here, which is important. We take your cash accounts and we put them into the trust, so that's checking, savings, money market, CDs, that kind of thing, securities accounts. We want to make sure we title those to the trust. Life insurance policies, which we'll talk about life insurance a little bit later, I want the trust to be the primary beneficiary of said policies. And the only thing that's a little tricky are what's called qualified plans. 401ks, IRAs, Roth, pension, that kind of thing. Those we want the order to be spouse, kid, trust, typically for tax purposes. And we can talk more in depth if you'd like on that topic. But what happens in this scenario if right here, if you die, you have a fully funded trust estate. You can see on the right, the trust estate has everything in it. And if you die right here, all we do is a simple trust administration. Within a fairly short period of time, everything gets disgorged from the trust, given to your family or whoever you designate as beneficiaries, charities, etc. And then nobody is unhappy, and it goes fairly quickly. But sometimes mistakes happen, right? The biggest one that happens, and it happens more often than not, so I do a lot of training on this subject, is what happens if you take the house out of the trust to refinance. There are a lot of banks and finance companies, they require you to title a piece of real property to you as an individual before they're willing to refinance it, right? So it's your responsibility to make sure that your trust basket, your picnic basket, is full of your stuff. And if in this particular situation you take the house out and you title it to your name and you forget to tell the title company or to supervise that process or to make sure that the escrow company does 2 deeds to put it back in the trust, and then you die, this is what happens, folks. It lands in your will estate. Remember, at death, you have both a will estate and a trust estate. So this is what happens. This house falls into the will estate, which is probate court. Okay, so do you remember at the beginning of this class, we talked about that pour over will, pour like a pitcher of beer. The pour over will names the trust as a beneficiary, and the only purpose is to connect probate administration and trust if you make a mistake. So we lodge a probate petition and we lodge this will, and it simply tells the judge, hey, judge, I made a mistake. I landed in probate court. I need you to transfer this back into my trust so my trust estate can distribute it the way that I say. Why is that important? 1, do you have a specific gifting proposal for the house? Let's say you want half of it to be gifted to 1 kid and then the other half to be gifted to 3 individual kids. You have an unequal distribution. The default in probate is equally at 18, right? So the default is probably not going to be what you want if you had unequal distribution desires. Let's say you had minor children and you don't want them to have everything at 18 because God knows, at 18, if I would have had anything, right? If Patrick and I were married at 18, I would have killed him off, put him in the backyard, and then I would have taken the money and spent it on jewelry and shoes and travel and who knows what all, but certainly not anything important, right? Okay, so you can see that now we have this connection, pour over will, trust estate. It goes back into the trust so the trust can distribute it exactly the way that I want. Now, probate is never, ever free. It's not free, it's not discounted, it's not faster, it's not more efficient, it just is. It is the default in the United States, by the way. What that means is if you do not take the time to plan in a way that a judiciary recognizes, the default is always the probate code, okay? So what is it and why do I hate it so much? Okay, probate is the first step in the legal process of administering the estate of a deceased person, resolving all claims and distributing the deceased person's property under will. What does that mean? It just means that your stuff languishes in the probate court process until the entire probate court procedure is done, however long it takes. First, the court has to decide if there's a will, right? So if we lodged one with a petition, is it valid? Does it have all those components we talked about? Are you over 18? Does it name your beneficiaries? If you disinherited your children, does it say that? Does the executor still want to do the job or are they dead? That happens sometimes, right? Your executor predeceases you and you forget to take them out and you don't have a backup. Then what happens? There's a procedure for that, right? After the entire probate process is concluded, then and only then are assets distributed. So you're probably asking yourself, so what happens then if I need the money? Well, good luck to you. If you are not the proposed executor and you do not have access to the bank accounts and you do not file a petition for any kind of spousal distribution or any kind of early distribution under probate, then you don't have access to that. So probate here, for example, I'm in Alameda County, takes about 1.5 years beginning to end, if believe it or not, right? Contra Costa is about the same. In an uncontested probate, I'm not even going to talk to you about when there's a contest, which is kind of ridiculous, right? So the default, again, if you don't have a will, right, or you don't have a trust, is called intestacy probate. That is where the probate code says this is exactly how everything is going to be distributed. So let me tell you a story. Years ago, I did a probate for a client whose mom had passed away, and she passed away intestate. So we had to do an intestacy probate. And when the money came out of grandma's estate after the probate was concluded, my client, ended up having kind of a falling out with his grown children because they thought that they should be entitled to grandma's estate. So he paid them some money, kind of severed that relationship, and then decided that he was going to retire with his second spouse to Italy. So a couple of years later, liquidated their entire California assets, left cash here, and then moved to Italy. So when he left, he's like, okay, now I'm going to retire with my significantly younger second spouse, and I'm going to go to Italy. And he started sending me pictures of this beautiful farmhouse he built and all this wonderful stuff that was happening in his life. And me, because I'm a lawyer and that's just my nature, every time he sent me an email, I said, well, did you do planning? And he's like, oh, well, no, I'm not, really old enough, and I'm fine, and I'm not sick, and there's, I'll do planning later. It was like, but you saw what happened to your mom's estate. So this went on for a period of a couple of years, and unfortunately, he ended up having an accident, right? A fire in his kitchen, and he died like 8 weeks later. So he had assets, if you're tracking this story, he had assets in Italy, and then he had assets here in California in the United States. I ended up having to do a dual part probate. We had to do an ancillary probate in Italy, and then we had to do a primary probate here, which is where his stuff was in California. Because he had separate property, right? So the inheritance that he got from grandma, from his mom, to him was separate property assets. And because he hadn't taken the time to write a will that said everything to my spouse and then afterwards to my children, the children that he didn't have a relationship with actually ended up getting 2/3 of the estate. So his wife that he'd been promising he's going to take care of with all of this money that he got from his mom's estate ended up having to go back to work, because by the time she paid the attorneys, because of course it was a contest and it took about 4.5 years from beginning to end to finish, she ended up having nothing and had to go back to work. So that is a prime example of why you should do, if nothing, you should at least do a will, right? So that at least your voice is the one that's heard in this probate process if you're not going to follow my instructions with regards to trust planning. So what is the cost of probate, which is the other big thing? I think a lot of people don't understand how it's calculated. So what I want to highlight is it's the gross asset value of the thing at death. So if you own a home that's worth $500,000 and a $400,000 mortgage is assessed on it, the probate fee is on the basis of the $500,000 date of death value, right? Not the net equity of the property. So in this case, you'll see to $26,000 fee that has to be paid to pull that $500,000 house out of probate hawk in order for it to get distributed. So the only way you're going to pay zero or a nominal fee, because obviously no attorneys work for free, is to actually put that into trust and protect it that way. So why people avoid getting an estate plan typically, they think it's too expensive. I have a lot of people calling me and they say, oh, well, I have a checking account and I have a house and I have a couple of retirement assets, not a big deal. I'm not spending a lot of money. Well, that's fine. You don't have to spend a lot of money. I'm sure there's a lot of cheap places you can go. So they think it's too expensive. The next, they think their estate is too small to support the expensive planning. So that the client that calls me and says, oh, I have a fairly modest estate, and then I calculate the probate fee for them, and it's something like $30,000 or $40,000. So for purposes of probate, you're actually richer than you think. So just kind of think of that. And also the basic here. So here in California, we have a threshold of $150,000 in gross assets before you can open what's called a traditional probate, like a first run probate. So it's $150,000 gross. Remember that. We have no offset for debt. The court does not care about debt. You have to pay it, but they don't calculate it for fees or to determine whether a probate has to happen. The probate fee on a $150,000 estate is $14,000, folks. $14,000, right, for a basic $150,000 probate. If you're spending $14,000 on an attorney to do planning, then you have a fairly significant, complicated estate that needs to be protected with CRATs and CRUTs and LLCs and all sorts of things like that. The basic planning should never cost you that much money, to be honest. This next one, want to initiate probate proceedings at death. I happen to be Romanian, and this particular line is for my dad. Many, many years ago, I've been doing this work for a really long time. And many years ago, I would, come into the house and I would say to my parents, especially my dad, hey, Dad, I think it might be time to do a trust. And so I tried to explain it to him. And he looked at me and he goes, what are you trying to kill me for? And he'd go in the backyard and start gardening. So this actually went on. This was a pattern that happened over a period of, I want to say 3 years. Every holiday, birthday, pop-in visit, I would kind of sidle up to him and say, hey, look, my brother and I, you don't want to go to court, we want you to do this trust. And he'd say, stop trying to kill me and go in the backyard, because it's not a thing that happens in Europe. Trust planning is just not a thing. It's mostly United States, right? And it's just now starting to come around. So finally, after a few years, I'm happy to say that I got him to finally do his trust. I think I threatened to kill him, if I'm not mistaken. I am kind of violent. So I threatened to kill him. He got his trust. Now he's super happy. I have a lot of clients that are superstitious, actually, but I'm happy to report that at no point have I ever seen any of my clients, I'm knocking on wood here, various parts, have ever passed away after we've done their plan. So that's good to do. So what happens if you don't do anything? Again, there's a default. In whatever jurisdiction you are, there's a default. You can be incapacitated and conserved. And conservatorship, incidentally, means complete control over your stuff and your person by probate, right? It's a probate court judge that decides which petitions they're going to accept, what expenses they're going to accept, right? The court controls everything about you, your person, and your stuff. You can be brain dead on life support. At death, there could be that court proceeding that determines what happens to the kids. Incidentally, if there is no guardianship in place, or you don't have a guardianship nomination in place, and there's any kind of a fight that causes any instability in the child's life, that child will be put in foster care. So just think of that. Assets can be distributed according to state law, which is that probate and then intestacy if you don't have anything. And then if you have much, much larger estates, and by that I mean estate taxable estates, the family money can go to taxes instead of to the heirs. The kids blow inheritance because you have no control over it. And there's usually a lot of fighting amongst the beneficiaries left behind. So who needs a trust? This is typical. Everybody, but particularly if you own real property. If you have home or land, regardless of anywhere in the United States, right, I want you to do a trust. If you own any property outside of the United States, please, please, please do planning in that particular jurisdiction. Italy is a very easy jurisdiction to actually transfer. So all you do is you go down to the local, their office of the local notary, and draft exactly what you want. It doesn't have to be really complicated or fancy to get it done. There are other ways of complicated estate assets transfers in different countries. So you want to make sure that whatever the rules are there, you follow that, and you tell that particular attorney that you're doing a plan here in the United States where you are primarily living, right? So you want to make sure that there's a connection there. Do not take foreign assets and put them into your US-based trust because that increases your estate tax bill, okay? So do not do that. If you have assets that are valued over $150,000, remember that's gross, right? The court doesn't care about your debt. I mean, you do, you should, your family members should. But for court probate purposes, it's $150,000 gross. If you wish to spare your beneficiaries the burden and the cost of probate, please, please do planning. And then if you have specific distribution desires, so for example, if I had 3 children and I only liked 2 of them and the third I did not like for whatever reason, either they were an addict or I mean, it could be something nice, like they won the lottery and they don't need any money, whatever. If you have a distribution desire that is not equal per beneficiary, you want to make sure you put that in writing. And then if you have much larger estate taxes and subject to estate tax risk, then you definitely need a trust. So with that, we're going to dive into this estate tax concept, and feel free using the chat feature to ask questions as you kind of go along. If you think of things, I'm sure you will. This is not as comprehensive as it could be if it was many, many hours long. So go ahead and do that. So let's dive into this estate tax. 2 fundamental rules. 1, unlimited marital deduction. So you remember at the beginning, I talked to you about my friend Patrick, and he has this $20 million estate that he got, right, from his little aunt. So when he dies unexpectedly, even though he's slightly underneath my pool, any amounts that he gives me, his spouse, I don't have to pay tax on. I don't have to pay tax on it until I die, right? That is the first rule. The second rule is that there is an applicable coupon or exclusion amount, which is the dollar value that the IRS says they will not tax that goes to your non-spouse beneficiaries if you do A, B, and C. The whole purpose, people, of actually getting any of these discounts or things that happen is you have to follow the government's rules with regards to what you need to do ahead of time, right? That's the key. So how does this look? Right now, the estate tax coupon, that's the amount that you can protect to your kids without having to pay tax, is $11.4 million a person. Most of you on the call are probably saying, well, then why are we talking about this? I don't have that much money. Well, the reason why we're talking about it is because this particular tax gets messed with every year. and depending on who's in office, gets messed with every year. And not too long ago, the estate tax exemption was $600,000 per person. So think about if you own a shop. Think about if you also own a house. Think about if you have a rental house and how much the gross value of those three things are. Are you close to the 600,000? Are you close to $1 million each? Think about that. So the reason why we put it in the plan is just in case. I don't know what's going to happen. I can't grandfather in the estate tax exemption at death. I have to deal with whatever the law is at death, right? So we plan for it now just in case. So let's show exactly how we can preserve over $22 million in estate tax free to your heirs. So the rule then is you have to use the family trust, which is the IRS coupon that I talked about. So in all of my illustrations, I always kill off the hubby because statistically you guys pass first, not because I hate men. So hubby and wife, same amount of money, right? You can see that both of them have $11.4 million in assets, so almost $23 million in a total estate. Hubby dies, suspicious circumstances, not necessarily underneath my pool, don't look there, leaves everything to the wife. Remember that first rule, she gets everything, unlimited amounts come to her, she doesn't have to pay estate taxes. But these little people forgot to do the trust beforehand. So you see at the bottom, she only has one coupon, right? Because he wasted his by not doing the trust before he dies. She has her money, his money, their money, and then only the one coupon she's allowed to use, which is $11.4 million in her death, which means the kids get to pay almost $4.6 million. The top tax rate is 40% in tax because they didn't take the time to do planning ahead of time. Okay? So if the same couple, husband and wife, do a trust beforehand, so the key is you want to make sure you do planning before you die, okay? Same scenario, hubby croaks, he's in the backyard, all the money that he had goes into what's called the family bypass trust. They take that $11.4 million, throw it in the family bypass trust. Wifey can actually pop into that trust to get HEMS, which is health, education, maintenance, and support payments to keep her in the lifestyle to which she was accustomed before death, right? Plus she has her money that's in her survivor's trust that she can use to do whatever if she, gets a new hubby or, I don't know, finds somebody else to be with, right? The money that's in the bypass trust goes to the kids at wife's death tax-free, no matter if it's appreciated. So if your $11.4 million is now $30 million, that goes to the kids tax-free, people. It's a big one, okay? And then we've used her coupon, so the tax bill to the government is zero. So this is how you want to properly die if you have an estate to worry about, okay? Or even if you don't, this is how you should do it anyway, right? You want to make sure you have that trust in place. So why do we care about estate tax and why do we even bother talking about it? Well, because I don't know. I mean, I honestly don't know what's going to happen. And it's supposed to, what's called sunset in 2025, which is supposed to go away. I don't believe that. They also talked about it sunsetting in 2010. That didn't happen. So you can see that it keeps increasing. They're talking about decreasing it. Who knows what happens? The point is the top tax rate is 40%. So handle it now. Please, please, please do not wait. So assets that are included in the definition of estate, this is for estate tax only. It's real property in any state. This is not calculated the same way as probate, so it's the net real property value. All of your life insurance policies, even if they're paid to somebody else, so think about that. You may think that you don't have a taxable estate for estate tax purposes, but did you consider the life estate portion of it? What does that look like? All your liquid accounts, checking, savings, annuity, etc., business interests, no matter how they're held, your business interest is included in that. Retirement and pension plans and all of your personal property, including your 20-year-old shoe collection, that is also included. So let's talk about the next topic, which is life insurance, also one of my favorites because most of us on the call are uninsured or underinsured. Life insurance is a wonderful way of, one, building wealth. There's a lot of really, really great possibilities out there of actually taking money and making money on it. So I have policies that pay me 15%, which is awesome. You can have that immediate cash inheritance for your family, right? We want to make sure we have enough money to pay for the debt of death, right? That's the primary thing that we use life insurance for, which is actually why I put life insurance and I name the trust as a primary beneficiary. When I say it's not your parents' policy, they've morphed. They have some beautiful life insurance products that are out there that exists to take care of everybody. And what I don't want, though, is the thing that happens a lot. So there's a statistic out there that I'm pretty sure is accurate that says 90% of widows file bankruptcy within the first 6 months to a year of death because they don't have enough cash to take care of themselves, if you can believe that, right? So whether that's accurate, not accurate, I don't know. I don't want to risk it because life insurance is actually quite cheap to get if you get it early, right? The thing that I want you to ask yourself, though, when you decide how much life insurance to get is, can your heirs absorb your gift? So I have a lot of people that come in and they say, okay, well, I have minor kids, right? So they're 10 and 12, and I have a house and a business and some cash and whatever, and I'm building my retirement, right? I'm in the building phase of my life. So you want to gift all of that to your kids. Your kids are your beneficiaries, correct? Can they absorb it? Meaning, can they pay for your gift? Can they pay for the mortgage? Can they pay for any of the debt? Is there enough to actually satisfy any of those things before they get anything? Wouldn't it be better if you use life insurance to pay off that debt so that they actually get a gift without any ties? You know who comes after them if they don't pay their debt? The IRS. That's really fun. So there's these index policies which you can talk to your own life insurance professional. Index policies that actually give you that the cash value, the savings component, which offers this market protection. It allows you to tie to the stock market. I'm not going to bore you with all the details, but there's some really great ways of making money. So we talked about supporting family expenses with that money, pays off your mortgage, covers educational expenses, particularly if they're in an expensive college, right? It can replace that income for the family, particularly if there's a primary income earner and then a stay-at-home parent. Pays for that final expenses, inheritance for heirs, the taxes, if there are any, create a source of savings. You can see that there's a lot of beautiful ways of using life insurance to make sure that what you want is actually what happens. So let's talk about some real life examples. Terry Schiavo, I don't know if you guys remember her, but the Advanced Healthcare Directive that we talked about at the beginning of this class talked about how you give your agent the ability to make your medical decisions if you become unconscious, unresponsive, right? So medically done, essentially brain dead. So Miss Terry had a brain aneurysm at 30. And she did not have a plan in place because at 30, who thinks they're going to die, right? I mean, that's not a thing that happens, not a conversation that happens over beers on a Friday, right? So she has this aneurysm. She's married at the time. Her mom and dad, but particularly the mom, thinks that she's going to wake up. The husband's like, nope, I think she pretty much doesn't want to be hooked up to life support. So unfortunately, what happened is they, over a period of 13 years, and by this point, the ex-husband, because he had gotten married to somebody else, they had court battles 13 years, and her body finally gave out. So the underlying court never got resolved. That petition never got resolved over discontinuing her care. So if you have an advanced healthcare directive in place, it gives your family the guidance about what you want. What does that look like for you? Please make sure that you communicate that to them. Leona Helmsley, I mean, the only reason I mention this woman is because I have a dog that I have a pet trust for, and you can really put some really nice money aside to make sure that your pets are taken care of. She actually specifically disinherited her children, right? Didn't like her kids, and put $12 million in an estate for this purse dog, this Bichon Frise that she had by the name of Trouble. The rest of her billions had to be probated. Incidentally, that probate is still not done. It's been years. Her nephew is the successor executor. The kids, her sons, once mom passed away, successfully petitioned the court saying, you know what, the dog doesn't actually need 12 million because he's small. He's not going to live that long. And so the dog only has 5 million in trust, and the rest of it they ended up taking. They disgorged out of the trust and gave to them. But my retirement plan at some point is to find this dog and adopt it, because it has like a house and a chauffeur and a masseuse and a professional chef. And I mean, who doesn't want any of that, right? So the estate of Charles Manson, I know you're probably thinking, well, wasn't he in jail? And what kind of an estate does he have? And he actually has a lot of intellectual property assets now, particularly since death. And he has a quote unquote grandchild that came out of the woodwork and said he was related to him. So I don't know what that's going to happen with that particular probate, but that's going to be an interesting one. What I want to highlight about Robin Williams is to be specific, right? Be specific in your plan, be specific in your intention. So Robin had a very, very nice, expensive team of lawyers, right, that drafted his trust and did everything in his plan. He was married to a woman, and they had a young child, and he had older children from previous relationship. In his plan, in his trust, it said, at my death, the home to my wife. What he hadn't written and maybe hadn't contemplated with his lawyers is that he didn't say the home and all the contents thereof to my wife. So within a week of death, his older children filed a petition saying, you know what, we'll give her the house. We're not going to contest the fact that she is, this woman, Susan, is allowed to have the home, but she's only allowed to have the four corners of the house. Everything that's not hers inside the house belongs to us, his natural beneficiaries, and so it needs to be taken out of the home and distributed. So most of us don't have Robin Williams money or notoriety or fame, which is fine. There's nothing wrong with that. But you have stuff. And if anybody cares about the stuff, please make sure that you're very specific and very careful about your intentions. Write lists. You know, I'm a huge fan of lists, and put it inside your trust binder that says who gets what of your stuff. I have clients that put stickies on the back of things, back of furniture and artwork and things like that. And yeah, you're kind of relying on the truthfulness and the honesty and the integrity of your beneficiaries so they don't swap stickers and things like that. I think, you know, because that happens also, but just be intent. Have some intention. The estate of Burt Reynolds, really interesting. I'm surprised that he didn't have a plan in place, to be honest, because he had so many lawyers. So it's just, there is a default, right? So Burt Reynolds is a default if you ever had the time to look at both Burt and Aretha Franklin in terms of what happens to their stuff, because those petitions are going to be very public. Prince, this one's really interesting. He hated lawyers. He didn't have a plan on purpose, actually, because he hated lawyers very much. There were 6 competing petitions that were filed immediately after his death. So they're talking about a loss of between 130 and 140 million in legal fees, people, taxes, fees, and court costs before that petition gets resolved, that estate gets resolved. I don't know what's going to happen to that one. And this one is a recent one. Karl Lagerfeld actually passed away not too long ago, and he had this very beautiful cat named Choupette that has a very kind of wealthy estate, and then an Instagram and you know, very, very popular cat. They're talking about it being the richest cat in history because he set aside a fairly significant amount of money to take care of that. So the point of all of that is you can leave your money to anybody. You don't necessarily have to meet it to your quote unquote natural beneficiaries, but you want to make sure that you're specific and then you put things down in a legal way. So do you need a plan? I don't know. Again, all of this is primarily geared towards California residents. So if you're anywhere near me, I'm in Pleasanton, California, come see me. You can come see me for free. Come over, talk about what kind of planning you need, and we'll figure it out together. You can always email me questions at any time about anything having to do with planning, and I'll do my best to answer them. And then I have one more thing, because I have a lot of clients that come to me and they say, well, you know, why would I go talk to a lawyer if I can go to one of these documentation companies? And so what about LegalZoom, for example? So let me show you this. It's a meme that somebody sent to me. So the top part is, you know, if you use a lawyer, then you get Aquaman, and if you don't, then you see. So not to poo-poo LegalZoom. I've had quite a few clients that have come to me with LegalZoom plans, and I've had more than one probate that started with a LegalZoom plan. The important thing is you want to make sure that it's done properly. And again, that funding that we talked about, I've talked about it several times in this class today, in this webinar today. Make sure you fund properly, and then you know at that point what you're getting. So any questions, I am happy to take them.
Awesome. Thank you so much, Daniela. That was absolutely amazing. Thank you for the information. And I have a couple of questions that have come in here. If you go back one slide to your contact info, everybody can have that information, take a picture. This is Daniela's information. Thank you. So the first question comes from Becky, and her question says, how difficult is it to move all of your assets into the trust? And the second half of this question says, do you have to open up new accounts, or is it easy just to do a name change? And I think this is 2 different questions.
Yeah. So thank you for that question. And the answer is pretty legal. It depends. So typically, I help all of my clients transfer their real property. So if it's real property in other states, I'll reach out to attorneys out there to draft those deeds, and then I usually execute them with the client to make sure that gets done. With respect to their individual accounts, the answer is it depends on the bank. It used to be fairly easy and uncomplicated several years ago, and I've heard in recent years that the banks have gotten more complicated, and they may require you to close accounts and reopen them into the name of the trust, which sounds like a big hassle. But I think that if you do it once, you should never have to do it again. So I guess the answer to that is also depends, right? It depends on the bank that you're working with.
Yeah, yeah, interesting. And a reminder, everyone, go ahead and chat in your questions. They're coming in fast and furious now, Daniela. So thank you very much. Next question comes from Bob. Question is, what if you get a terminal illness? Is there anything that you can do to protect your assets from the state taking everything you have?
Perfect question. Yeah. If you get a terminal illness, you know, when it's too late is when you're dead. So the threshold for planning is called capacity. And the threshold is actually fairly low. Your legal capacity to plan is fairly low for court purposes. So typically right after diagnosis, if you haven't done so already, run to your nearest attorney and make sure you get a plan done. Because when it's too late is when you're dead, and then that's when the default kicks in. So the default probate code kicks in, which may not be what you want.
Wow. Yeah. Yeah. No, definitely get it taken care of quickly as possible. Tom's got a quick question here. Do you need to have a will or a trust, even if it's only a spouse and one child?
Absolutely, because that really depends on what you have. So let's say you have a spouse and one child and you decide not to do any planning, right? And your spouse is a joint owner to all of your assets. That's one of the ways of avoiding probate, right, is by joint ownership. So you die first, and then everything goes to your spouse, who's the joint owner, right? And then she dies. Well, there's no connection right there without probate between her and the kid. Does that make sense? So you have an opportunity to do planning while both of you guys are alive to make sure to take care of both of you plus the kid. But you've lost that opportunity by giving everything to her, and then she dies. Incidentally, there's a tax basis, a tax savings for having things gifted to somebody in trust. For example, here in California, when I don't want to muck up the works here with this conversation, but in California, we have community property. We're a community property state. And for capital gains purposes, if you have a piece of property that you hold as community property with rights of survivorship, there's what's called a double step up in basis. So when one of the spouses passes away, the surviving spouse gets a double step up, which means their cost basis for capital gains purposes is at the date of death value, which could be significant if capital gains is assessed at 25% over the basis. Basis is the purchase amount. I don't want to muck up this thing, but really there's what you want to take away from that is there's the significant tax savings that exists if you have planning through trust versus just allowing the joint tenancy or joint ownership to control.
So in this scenario, even if dad passes away, mom is still surviving, they have a single child, mom passes away, and this child is let's say the child is still a minor. There's no tie between the child and the mother unless there is a will or a trust in place. There's no.
Right. The default is probate. So in that scenario, dad leaves everything in joint ownership to mom, right? Mom dies and the kid can't get anything until there's a probate. And if the kid is under the age of 18, then they have to issue what's called a guardian ad litem, which means they keep all those assets in probate until the child turns 18, and then they give everything to him at 18.
Wow. Yeah. Wow. Interesting. And a question now coming in from John. Question is, should you have everything in a trust? And I think in this scenario, he's thinking, do you want to put all of your eggs in one basket, quote unquote?
All of your eggs except for retirement accounts. So anything that's called qualified, so think retirement, think pension, 401k, IRA, Roth, those kind of accounts don't go into the trust. There's only specific circumstances that allow that to happen for tax purposes. So what we like is live humans to be the beneficiaries of those accounts. But for my clients, I ask them to name the alternate contingent beneficiary as the trust because in my trust planning, I have you do what's called a disaster beneficiary so that if you and the primary beneficiaries die in the same incident, then I want to avoid probate at the second level. That's the disaster level. And then that's when all of those assets would come in.
Wow.
Does that make
Yeah.
sense, or did I confuse you?
Yeah, no, it absolutely, there's so much that goes into this.
It is.
And at the end of the day, what I'm really hearing is you definitely need to have an attorney to look at this with you. And what I get from this also is that an attorney is able to make sure, one, that you're totally covered, because you may put wrong things in your trust that you're not supposed to put. And two, it's customized to you, your scenario, your exact situation.
Absolutely.
Yeah. All right. Another question coming in from Christina. And this is about wills, trusts, and LLCs. So instead of doing wills and trusts, could you create an LLC company with all the people you want and things to go to? With the examples of a house, I could just have my spouse and my son in the LLC, and upon my death, they would just have it. Is that how that works?
So the answer is maybe. The only way that you're creating an LLC is if you have a business. The government won't permit you to create an instrument just for estate planning. You have to have an LLC run an actual legitimate business. Otherwise, you can't take any of the write-offs. You can't do any of the transfers. And if anything fails, it's automatic probate court. Right? So you're not going to take the home that you live in.
Yeah, and chances are you haven't been running this LLC as a business. It's just sitting
Correct.
there as a shell, right?
Exactly. And the government prohibits that, actually. It's a specific prohibition. An LLC is, by definition, it's a limited liability company. If you do not have a business, you can't have it. You can't just throw your assets in there because you want to have one way of passing it to your family. You have to have a legitimate business reason before you're able to actually use it, because it's used as a shield, for example, for liability purposes, for any kind of business actions. I mean, you can put your things in there. There's also no step up in basis when you get assets through an LLC, by the way, from a tax perspective. So for example, let me give you a highlight of the thing that we care about the most, which is the home. Say you live in a home and you have 2 kids and you bought the house at $100,000, and at your death, the house is worth $1 million. If you pass that home to a beneficiary through an LLC, there's no step up in basis. If they sell it, they have to pay the capital gains difference between $100,000 and $1 million, right? I'm not going to bother to do that math because I didn't go to math school, but it's very expensive, right? If instead you take that house and you have it in trust and you give those children that house in trust after you pass away, the step up in basis is the difference between 100,000 and $1 million, which means that their cost basis in the property at death is $1 million. If they sell it the next week and it's $1,100,000, they're only paying capital gains on $100. Does that make sense?
Oh yeah, yeah. Because it's protected properly. Interesting.
That's correct.
Okay, guys. Hey, continue to send in your questions. The chat is absolutely blowing up here, Danielle. This is absolutely wonderful. Next question comes in from Nick. And it's a basic question. I know it's on everybody's mind. On average, what would the typical family be looking at spending on an estate planning to avoid probate?
Perfect. For me, my general range, I do offer a discount for people that listen to me on these webinars. So you can expect about $2,500 for a single person and $3,500 for a couple. $3,500 rather, not $35 for a couple.
Okay. So anybody in the state of California can come and use your services, correct, Danielle?
Absolutely. And the consultation is free because I really want you to concentrate on planning, not looking at the clock above my head. So the consultation is free, and then the plan is customized. Absolutely.
Beautiful. Beautiful. Next question comes in from Ron. This is an interesting question. And it's, I believe, the dream of us all, retiring to a Caribbean island or retiring somewhere outside the United States. Question is, I currently live in the United States now. I have a home in Mexico, but when we sell our shop, we plan to move there full time. Is it complicated to set up a trust and handle foreign homes like this?
Okay, so back to what I said somewhere in the middle of this class, you do not want to take foreign assets and put them into your US-based trust plan. That increases your estate tax bucket. So what you want to do is if you retire and you still have assets in the United States, keep your US based trust, right? So you're going to take the trust and have everything in the United States in it. Bank accounts, real property that's in the United States in that trust, and it will be administered after your death by a US based trustee. If you don't have anybody that lives in the US, I would recommend you hiring a professional fiduciary, a professional trustee, and naming them to that instrument. When you move, Mexico, for example, has different rules with regards to ownership. You actually cannot, unless you're a Mexican national, own real property. You can only lease it from the government for up to 99 years. They have intestacy provisions and testacy provisions in Mexico that you have to follow with their respective rules. So whatever you own in Mexico, you're going to go talk to a Mexico attorney to actually make sure that that plan is in place, and then you have a separate United States plan. Do not combine the two.
Nice, nice. Great advice here. And I saw two different scenarios. One, if Ron sells everything and is completely finished with anything United States, no assets in the United States, he needs to have a Mexico trust. If he still maintains both, he does need to maintain a trust in both countries.
That's correct. And really at that point, it has to do what his tax basis is. If he liquidates everything and just wants to take the cash and can kind of bypass that $10,000 per person transfer thing without having to pay tariffs. So you have to kind of think about that whole component of it. The bottom line is make sure you work with attorneys. So you don't want to do any of this stuff on your own. It's like brain surgery. You don't want to go to a dentist for brain surgery. So go to a proper attorney to actually figure out what that looks like. If you liquidate everything, does it make sense for you to take the liquid assets and put them into Mexico where you're going to live? Or does it make sense to leave it in the United States, perhaps where it's guaranteed, right? We have FDIC insurance on monies here that may not necessarily exist in other jurisdictions. So you want to kind of think about all of that.
Yeah, it sounds like Ron is going to have a trust in both places for the security of his funds. Yeah,
that is
and
true.
security in Mexico. Nice.
Right.
Okay. Question coming in from Rocky. The question is, I have a living trust. Should every asset be named in that trust, or is it automatically part of the trust since it's under your name?
Okay, nothing's automatic. Funding is actually a paperwork process. So when you receive a statement, and let's say you, again, back to the thing that we talked about earlier, which is the Smith Family Trust dated December 1st, 2018. Everything should read Jim Smith, trustee of the Smith Family Trust. Your statement should read that. The deed on your home should read that. If it doesn't read that, then that asset is not in the trust. There is no such thing as automatic funding. You actually have to do the paperwork to put it in there. Does that make sense? So if you take it out, you want to make sure you put it back in.
Right, and that's going back to your refinancing a house scenario. Once you have it refinanced, put it back in, make sure that does happen.
Right, and what that means is two deeds. So when you take it out, you're going to get a recorded deed that says from Jim Smith, trustee of the Smith Family Trust, to Jim Smith, individual. And then you have a second recorded deed. So that little stamp has to be on there, upper right-hand corner, where it says Jim Smith, individual, back into Jim Smith, trustee of the trust. Does that make sense? Okay, perfect. Yep, that's funding.
It has to go back. Interesting. Okay. Another question coming in from Bob, and more of an interesting statement. And because he's saying it, I do want to address this, that a lot of shop owners feel like they're really not making a lot of money, like they really don't have a lot of assets. So the question is, someone's making a comment, but maybe it's just a question. I think since we're all shop owners here, you don't have to worry about any of us with millions. You should drop a few zeros. Ha, ha, ha.
Right. So for probate purposes, you're more well off and wealthy than you think. So what's important to remember is that all probate cares about is how things are titled, right? So if you own an asset as an individual and that individual dies, that asset probably is going to have to go through probate court, okay? And the probate fee is not on the net value of that asset. Remember, it's on the gross value of that asset, because again, the court doesn't care about debt when they're calculating the fees that they pay for the court itself, or for the executor, or for the lawyer, or wherever, like the probate referee, everybody else that's involved in this entire probate process, it's on the basis of that gross asset value, not the net. So in there somewhere, those debts are going to be paid if there's enough money, but you are much more well off for probate purposes than you think. So the default always is, if you own real property, please get a trust, because that is an automatic invitation to probate court as a home. So if you have a home, make sure you have a trust. And then the rest of it, why don't you sit down and just kind of calculate it one of these days? Calculate the probate fee on your own. And if you don't know what that is, send it to me and I'll calculate it for you.
Oh my word. Yeah, that's a sobering number to see when you see what probate's going to cost, which is perfect for this next question coming in from Doug. And I think this is a two-part question. Is there a difference between the cost for a trust and what is the cost for a will? Are they the same? Does it come in a package?
Perfect question. Yeah, so I do an estate plan, which includes every single document that's required to make sure you're protected. So for example, documents that I didn't talk about today because I don't want to muck up the estate planning presentation. I do, for example, assignments of personal property. I do community and separate property affidavits if you have assets that are owned either jointly or not. I do assignments of business. I do assignments of timeshare. I do whatever needs to be done to make sure that the plan is comprehensive. So your 4 general documents are going to be your will, your trust, your power of attorney, your advance directive, but then all of the other things that go into planning. I mean, I don't want to, but I think I kill a tree a day, with all the paper that I use, because it's really important to make sure that it's comprehensive. And again, it's unique to that client and what they need and what I need to make sure they have to make sure they're protected. So you're not paying a certain price just for a will or just for a trust. In fact, I don't do single document planning at all.
Oh, nice. So it's a full bundle. It's a full package.
It's a plan.
It's a plan. Love it. Love it. Craig says, thank you for doing this. I really appreciate it. I appreciate your time and the information. Thank you, Craig. We appreciate your comments. Tim's asking for a copy of the recording so he can later show it to his wife. Absolutely, Tim. We definitely will have this available for you to be able to watch it together again. Every time I listen to you, Danielle, I get new information. I get more information about estate planning and what I need to do. Even though I am not a shop owner, I know there are many shop owners out there. This needs to be done. This has to be top of your priorities.
Mm-hmm. Absolutely.
Because
I think everybody needs it.
We all know somebody, a shop owner, who has a house and has a shop, has a building. They own the dirt it's on, and mysteriously they pass away, or miraculously or instantaneously, unexpectedly, they pass away. What happens after that? And that's what we're trying to plan for now, is to make sure that that happens and happens properly. And we'll finish this off with the final question from Gustavo. Gustavo is asking, again, a clarification question from you, Daniela. And the question is, can you explain why LegalZoom or Legal Shield would be a bad idea for a will or a trust?
Yeah, so I showed you that really kind of funny meme. So in all seriousness, I've looked at LegalZoom products, and I believe that they start with a plan that's written by an attorney, but not necessarily an attorney that is in the jurisdiction where you live. So maybe the attorney comes from Pennsylvania and you're a California-based client. Again, California law is specific, right? The probate code for California clients is very specific. So if a mistake is made, which is often the thing that happens, right? They give you this plan. They don't tell you how to execute it. They don't tell you how to fund it. They don't give you any kind of support typically. And so you have a plan thinking it's great. You take it, you put it in the closet, you die, we end up doing a probate. Does that make sense? So a lot of what you should be getting when you establish a relationship with an attorney, and I want you to kind of focus on that. No matter if you hire me or go out and hire somebody else that's closer to you, or that you like better, or whatever your criteria is, you want to make sure that you get support from them. You want to make sure that you do it properly, fund it properly, maintain it properly. All of my clients, because I'm super pushy and picky, they get funding checklists for me every single year. Every single year with the holiday card, I send a annual financial and legal checklist that says, these are all the things that I want you to do. I want you to touch your stuff every single year, because at the end of the day, I want it to be properly done at death. I want it to do what it's intended to do. You're not going to get that same kind of service from these companies that are really, quite frankly, only charging you, $400 or $500, $600 to do a quote unquote plan. And then, you kind of get what you pay for at that point.
Yeah. Yeah. So true. Daniela, thank you so much for the information. Thank you for being a part of this with us. Thank you to you as shop owners for coming in. We at Kukui, we are bringing this all together under one roof. This is valuable information for you as a shop owner, for your life, for your planning, for your estate, for your children, your spouse. Let's make sure this is taken care of. And again, Daniela, thank you so much. Appreciate you joining us.
Anytime.